Hello, this is Professor Guerra Pujol from the University of Central Florida, and welcome to Legal and Ethical Environment of Business. As you can see, I'm standing in front of the Supreme Court of the United States because today I'd like to talk about federal jurisdiction. That is to say, when does a federal court have the power to hear a case, including the U.S. Supreme Court, for example? Now, this question is actually very important to this case, because, to our course, because if you look at the Winklevoss twins' complaint very carefully, you'll notice it was filed in federal court. The original 2004 complaint, though, presents something of a mystery, because if you look at it closely, only state common law claims are asserted, such as the ones we've been discussing in this course. For example, breach of contract, fraud, misappropriation or theft of a trade secret. All of these are state common law claims. Well, it turns out there are three important categories of federal jurisdiction. Let's go over all three. One category is when a case arises under federal law. When a case arises under a federal law, let's say you're bringing a bankruptcy case, which is federal law, or a federal antitrust case, or the government is bringing a federal criminal prosecution. When cases arise under federal law, whatever that federal law is, federal courts have jurisdiction to hear that case. The second category are cases involving public and private international law, especially when a case presents an issue arising under a treaty that's been ratified by the United States. In that case, Article 3 of the Constitution confers jurisdiction onto the federal courts. The idea here is that our nation's founding fathers wanted the federal courts of the federal system interpreting matters of international law to provide greater uniformity. The third and last important category is where the Winklevoss twins case falls under. This type of jurisdiction is called diversity jurisdiction. And diversity is a funny legal word referring to diversity of citizenship among the parties. Now, to understand this, take a look at the Winklevoss complaint. Who is suing and who is being sued? First of all, the Winklevoss twins and their company ConnectU, which is a Connecticut limited liability company, is suing Facebook, which is a California company incorporated in Delaware. When you're suing a company has two citizenships. The state in which it is incorporated, in the case of Facebook, that is Delaware, and the state in which it has its principal offices or it does most of its business. Now, Facebook does business all over the world, but its central headquarters, are in Menlo Park, California, one hacker away. So Facebook is considered citizen both of California and Delaware. Now, in this case, there is complete diversity of citizenship, since you have a Connecticut company suing a California/Delaware company. So the lawsuit may proceed. Now, it's true the Winklevoss twins also sue Mark Zuckerberg, Eduardo Saverin, Dustin Moskovitz, and I believe also Chris Hughes, the original founders of Facebook. Chris Hughes is originally from North Carolina, Zuckerberg from New York State, Eduardo Saverin, of course, from Florida, and Dustin Moskovitz as well from Florida. Now, in that case, you have two of the defendants are Florida citizens, but that's okay. What the rule requires is that all the plaintiffs on the one side and all of the defendants on the other side be diverse in their citizenship. And so that requirement is met here. Now, there's a second requirement for diversity cases, and that is that the value of the lawsuit be greater than $75,000. This is a very important jurisdictional requirement. In addition to the parties being from different states, the lawsuit, in other words, has to be a serious money lawsuit. If both of those conditions are met, then the plaintiff can bring his action, or her action as the case may be, in a federal court. I shall tell you, if the plaintiff chooses to bring the action in a state court, the defendant has the option of requesting a removal to a federal court if those two conditions are met. So let's recap the three main categories of federal jurisdiction. when can a plaintiff, when can a party bring an action in a federal court? Or when can a defendant request that an action be removed from a state court to a federal court? Well, now you know the three categories. If the case arises under a federal law, a federal statute or regulation, if the case raises issues of international law, including a treaty to which the United States is a party, and third and last, and very importantly, when there is diversity jurisdiction, when the plaintiff and defendant are from different states and the amount in controversy is over $75,000. Take a look at the Winklevoss complaint and you'll notice that that cause of that complaint meets both of those requirements. Well, thank you for your attention and have a good day.